listen to me. I'm going to start to make you appear in person. I'm not playing this little game with you. The case has been ongoing since 2018, and you didn't bother showing up, and now you want to keep delaying saying, I want a lawyer. I got a lawyer for you. You're going to either have to go hire your own lawyer like pronto, like today, or I'm just going to set it for a jury trial. I'm setting it for a jury trial today anyway, Heather.
Well,
I'm not going to play this. Excuse me. Don't interrupt me. I'm not going to play this game with you.
I'm not playing a game, Your Honor.
Okay. All right. Okay. You don't show up for 8 years.
I've paid a lot of
You
money.
don't show up. Listen, do not argue with me, okay? Do not argue with me. I'm setting this for a jury trial. Boy, you're sniffing a lot.
Yeah, I'm requesting a continuance. I need to get the
I'm
rest.
not giving you a continuance again. Denied. You're really sniffing. You got allergies?
I do have allergies, yes.
You got warrants out of Taylor, too. Do I look like the kind of guy that wants to play games? If I do, just tell me and we can have a candid discussion.
I've put a lot of money into this. I want it resolved. I just need help. I need help. I'm far away.
We're setting it for a jury trial. Give me a jury trial date in about 6 weeks. That's what I'm doing. She's done this twice. I want to go through this register with you, just so you don't think I'm being unfair.
I saw it.
It's ridiculous. I don't know who she thinks she is.
So what, I don't have any jury trial dates until maybe September or October. I can go get my plan and.
Go get it.
She's gonna be assigned.
Go get it.
Okay. Very good.
I need a continuance. Boy, you got the lingo down. Why haven't you shown up in Taylor? Why haven't you shown up in Taylor, Ms. Joseph? Don't answer that yet. Your lawyer went to get her plan. What is going on out here? You had, let me just shut my mouth until she gets back. Let me be clear. You were in here May 28th and you stood mute and you said nothing about hiring a lawyer. Then you come here June 17th and all of a sudden you've seen the light and you want to hire a lawyer. And I encourage you strongly and tell you you're going to hire a lawyer before the next court date. Now, this is after you've had multiple missed appearances. I'm setting a jury trial date. I'm setting this in 2 weeks. You're going to hire a lawyer or you can take this good court-appointed lawyer. But I'm not going to wait for you until the cows come home. Are we with one another?
I'm not sure what.
Are you listening to what I'm telling you?
Yeah, I don't know about cows. I'm not sure what you're speaking of.
Okay. Well, you haven't been here in 8 years. Okay? You're disrespectful. You want to play games with the system. You got warrants out of Taylor you haven't shown up on. What day do you have for a jury trial?
In September or October or August?
Do you have anything in August? I'll do it on a date other than a Friday if I need to. I'll be right with you, Deputy. Forgive me.
House Counsel on this August 6th and August 20th, those are Fridays. If you want to do the thing,
Call in the prosecutor, John. Please.
actually, well, those are Thursdays.
Who's this one on? Can you afford to hire your own lawyer, ma'am?
Pardon?
Can you afford to hire your own lawyer?
That's what I'm working on. I'm just trying to request like FOIA and get paperwork from the mental institution and other things. It just that's what I'm working on.
It's for speed.
I'm gone that week. I need to set a jury trial date. I don't know what to do with Ms. Joseph. How about August 21?
I got the 28th.
We'll set this for August 28th. I don't know why you're trying to represent yourself. Ma'am, I'm going to set it for a jury August 28th. I'm going to adjourn it for a final pretrial July the 15th. Bring your lawyer. I'm not discharging Ms. Patillo. Adjourn final pretrial July 15th at 8:30 in the morning. You need a lawyer here then, ma'am.
Okay.
Okay? We'll see you
Okay.
here then. I'm telling you, I'm not going to adjourn this and adjourn this and adjourn this. You lost all those rights 8 years ago when you stopped showing up. Good luck. Thank you. People against D'Artagnan Deputy, what do you have there? And I'll try to get them out of there. What do you have?
No, it's just real quick, Judge McNally. I just wanted to verify you were done with inmate Terrell Scott. That's all.
All he needed to do was meet with probation. Did we set that up, Heather?
Yes, Miss O'Donnell went in and spoke with him.
Okay, yes, we should be all done.
Okay, thank you, Judge McNally. I appreciate you, sir.
Deputy, have a great day.
You too, sir.
Heather, tell me when you can, if you have a William Mazie out there, will you please?
Okay, I do not at the moment right now.
Okay. Take your time. That's okay. Just take your time. Take your time. I don't want to get settled anyways. John, do you have Madeline's phone number, please?
253.
Bench, can you just walk through probation and then down the skirt all the way up to the bench and answer your question? Okay, thanks. You want to go on the record?
Right, yep.
Go ahead. Stroud? People against Jesse Lee Stroud, 25B149374A. Can
He's coming in on Zoom, Judge.
you?
Oh, victim. They were the owner of the vehicle. He was driving someone else's vehicle.
I see. Okay, I couldn't figure that out because you're building the details. Oh,
Yeah.
Thank you very much. Okay, Mr. Stroud, start your video, please, and state your name. How you doing?
Good. How are you doing? Jesse Stroud?
Wow, you're looking good there, Mr. Stroud. You didn't show up for court just like that on Zoom, did you?
Yes, sir.
Wow. Somebody's showing some respect. That's kind of cool to see if you're me. You know what I mean?
Yeah, I understand.
All right. Did you learn anything here?
Yes, sir.
I'm going to ask you to raise your right hand. You solemnly swear or affirm under penalties of perjury that the testimony you give in these proceedings will be the whole true self you got.
Yes, sir.
All right. Since you were in court and I sentenced you on the order of probation on October 22, 25, have you been arrested for any reason?
No, sir.
Any new charges pending against you?
No, sir.
And you haven't had any police contact?
No, sir.
Well, I wish you well, Mr. Stroud. I'm going to go ahead and dismiss the case on motion of the prosecutor. You were compliant. Good luck to you. Stay
Thank you.
clean now, will you please? Stay for yourself. Okay?
Yes, sir.
Good luck.
Thank you.
Marquita Nicole Collins, 246206. Good morning, ma'am. Your name, please? You're charged with driving on a suspended. You have the right to an attorney. If you want one, I will give you one. You understand that?
Yes.
Would you like an attorney to represent you? Okay, we're gonna give it.
I thought we was already explained that I have my license and my insurance, so I thought we had dropped it.
This is just to, we just scheduled this for an arraignment and a pretrial today. You haven't been in front of me on this yet.
Huh?
You have not appeared in front of me on this case yet. Did you?
Believe I did.
No. Was it another one?
Okay, it was another one. You say yes.
Okay. All right. I'm gonna go ahead and give you a defense lawyer. So you can go out in the hall and we'll set you up, okay? Good luck. Amy, somewhere down there, you should have a file with Mr. Hill as the lawyer.
That's this one right here.
Okay, perfect.
We don't have one.
Is Mr. Hill here and his client?
Yes.
That's, pardon?
Yes, they're both out here, Judge.
Okay, bring
want me to
them
bring
in,
them in?
please. This is People Against Todd Dwayne Johnson. Todd Dwayne Johnson, 2-6-7-13033. Your name?
Good morning, Your Honor. Alex Hill on behalf of Mr. Johnson, P76961. Mr. Johnson, will you state your name?
You have to start your video, Mr. Johnson.
Stream, okay.
Your name?
Todd Dwayne Johnson.
So I got a stipulation from your lawyer in an order to adjourn, a proposed order to adjourn that the prosecutor agreed to. But I did not do the arraignment on this case, and there are some bond conditions that I need to add, okay? There was a visiting judge in here at that time. So counsel, what would you like to say? I understand that the visiting judge gave him a personal bond of $1,000. I have no issue with that. But I do have an issue with, I need to address some bond conditions here besides no alcohol or drugs. So
Absolutely, Your Honor.
can you tell me when his prior was?
It was at least a few years ago. Mr. Johnson, what year was your prior alcohol?
2020.
2019 or 2020?
2020. Huh. What was the alleged, this is a alcohol case, but I'm looking for the breathalyzer or blood result.
I don't know the older case, Your Honor, but I know the present case, the alcohol allegation is relatively low. I haven't reviewed all the discovery, but my understanding is it's around the 0.1 level. But he does obviously understand the concern. He wants to show the court he's compliant with a no alcohol condition.
Over a 2-1 though.
For the first one or this one?
This one.
Okay.
He had a
I haven't-
227 on the first test and a 214 on the second.
That is a concerningly high level, Your Honor. We're not opposed to a testing condition. I don't know if Mr. Johnson is travel-wise to get testing. If, something like 2 times a month random would satisfy the court, but he would have to go, or if he wants to ask for a SoberLink device where he could blow 2 times a day or at the court's discretion to verify he's not consuming any alcohol. Mr. Johnson, do you have a preference between random testing set by the judge or a SoberLink device so that you can not need to go and report for testing on your days?
He's
Oh,
not
yeah,
going
I
to
mean,
get to, he's
yeah,
not going to
random
get, he's not going to get to decide that. Okay.
I understand. Okay, Your Honor. We leave it to the court's discretion, but he is ready, willing, and able to show the court that he's going to refrain from alcohol as this case proceeds.
I'm going to give you a number. Are you at home, Mr. Johnson?
No, I'm actually in my work van like right now.
Okay. You have a pen?
I can take it. for
Yes,
you.
I do. Yeah. Yes, I do. Hang on. Let me grab my notebook here like real quick. Okay, I'm ready.
So, counsel, why don't you write this down too? I'm gonna give him $1,000 personal bond. You cannot have any contact with prosecution witnesses except through your lawyer. You cannot leave the state without the consent of the court. You cannot violate any law or ordinance. You must appear in court as directed. You're to attend AANA at least twice per week. Counsel, if you don't have any AA forms, we will send them to you and you can get them to your client, but you're to immediately start going at least twice per week. And that has to be in person. Also, you must obtain a SoberLink device by the end of today. You must obtain a SoberLink device by the end of today. You're going to have him call this number in the probation department, 734-671-0201, extension 245. They're going to explain to him where he has to go to get that and what kind of cost there is. Heather, I want to know the pretrial date that you've given Mr. Johnson, Mr. Hill, rather, if you haven't, if you've done that already.
July 14th at 9:30.
July 14th at 9:30 will be the pretrial date. So you understand everything I said, Mr. Johnson, correct?
Yeah, yes, I do. The only thing is, as far as the device or what you're talking about, like, I'm kind of ignorant to that. I don't even know what that is.
I'll talk to you, sir. It's a
SoberLink device,
Okay.
it's a portable breath machine, and you're gonna have to blow into it 5 times per day. Don't
Okay.
miss a test, okay? Or the bond is subject to being forfeited. Understand?
Okay, and only reason I'm asking is because is that something I do it's something I can take with me, so I can take it from my personal vehicle to my work van to personal vehicle. It's something I just carry with me all the time.
Correct.
Okay, all right, okay, thank you.
So counsel, call the probation department and set that up and make sure you get them an AA form. If you need any assistance, you call.
Absolutely, Your Honor. We appreciate that.
Okay, and it's Pam's here today, right, Heather?
As far as I know, yes.
If not, you're gonna call this extension. What's yours again, Heather? It's
228.
228, okay?
Thank you, Your Honor. We look forward to moving the case forward on the 14th.
Thank you. Good luck, Mr. Johnson.
Thank you very much.
Salvatore Gabriel Damadio, 26B839-108.
Johnson.
Right up to this podium, sir. That's all right. Your name? How you doing today? You're charged with animal vicious act. That's a misdemeanor. You also have 2 civil infractions, no dog license and dog roaming at large. You have the right to a lawyer. If you want one, I will provide you with one at public expense. Would you like an attorney? Yes. Okay, you can go right out in the hallway. We'll set you up with a defense lawyer, and then either way, you're coming back in front of me today, okay? People against, Shannon Sherelle Phillips, 26B150905A and B. Good morning, ma'am. Your name? Okay, do you have your discovery yet, ma'am? Everything you need?
No, I just received it yesterday afternoon at about 12.
So you have it now?
Yeah, but I haven't reviewed.
No, I understand. I'm just, that's what my question was. Do you have everything that you need?
Yes, I just got the email. I didn't really go through it. I think like 4 attachments. But yeah, I did receive discovery.
Okay, so we'll go ahead and you can review all that. I'll give you a 2-week adjournment. We'll set this for July. What are we doing? The 15th, Heather?
Yes, July 15th at 10 o'clock.
And you still don't want an attorney to represent you?
No, sir.
Okay. July 15th at 10. If you change your mind, can you afford your own lawyer? I'm just curious.
Yeah.
Okay. Okay. Right. So if you can afford your own and you decide to hire one, bring him or her with you. If you decide to represent yourself, that's fine. I'm still going to suggest you get a lawyer, but you do what you want. You have the right to represent yourself. Okay?
Yeah.
Go down the hall. They'll give you a paper notice. Good luck. You're welcome. Fleming, D'Artagnan, Kenyatta, Fleming, 26B 14998, 1A and B. How you doing, Mr. Fleming? Good. Your name? Okay, just keep your voice up nice and loud for me, okay? All right, you have a charge of trespassing and consuming recreational marijuana in public. That's a civil infraction, the recreational consumption of marijuana in public. The trespass is a misdemeanor. You have the right to a lawyer. I'll be happy to provide you with one if you would like one at public expense. Would you like an attorney?
Yes.
Okay. I'll get you a lawyer. Just remember, you have to enunciate everything and keep your voice up when you come on back, okay? So we're going to set you up with an attorney as well. And after you speak with your lawyer, you come on back in with your lawyer, okay? Good luck. Is Mr. Quartz ready on his sentencings?
He was reviewing something with fine.
Mr. Quartz, are you ready?
Yes, I am.
Bring your client in, please. Morning to you. People against Jacob Michael Douglas, 24B1470488.
Good morning.
Hang on one second. I also have 24B1470755B and 24B1470448B. All right. Good morning.
Good morning, Judge McNally, Thomas Courts. Here on behalf of the defendant, sir, please state your name for the record, please.
Morning, Jacob Douglas.
All right. So let me just recap here. He pled guilty to operating while impaired due to the consumption of drugs. He also pled guilty to failure to report a property damage accident. The original charge of operating while intoxicated due to the consumption of drugs or operating while with the presence of drugs was dismissed, and as was the leave the scene of a property damage accident. He also has an outstanding civil infraction in front of him that he did not pay dating back to 2023. I mean, it was the same date. They've got a different case number. It's just 7075B instead of, I'm not sure why they were not consecutive here, but at any rate. So I referred him for a screening and assessment. Have you had a chance to review the report with him, and are there any material additions, corrections, or deletions?
I have, Judge, while it was accurate at the time, there are two updates I'd like to share with the board.
Okay,
His employment status has changed. Instead of working at Arby's,
one second, Amy. Okay, instead of working at Arby's part-time, he's what?
he's now working, doing gutters. He's now doing gutters at Gene's Construction Company.
Okay, I'll modify the report in that aspect.
And then, Judge, there's also, his 2-year-old child. The mother has lost her job, and so now he is providing, assistance and help with.
Okay,
Besides that, Judge, we believe the report to be, fully accurate.
all right. Anything you would like to say on his behalf?
Judge, thank you. The case is from 2023. That's not the behavior, but it is to say, Judge, that there's a slightly different person that stands in front of you. He came to court today. He's voluntarily trying to handle his legal matters. He's working, he's employed. He's got a child. Back in 2023, he didn't have a child. My client, this is a drug-related problem, and he's telling me that if we were to test him today, he'll test positive, Judge, which really changes the whole dynamic of the.
He will test positive?
Oh, I'm positive. Sorry about that, Judge. He's positive that he would test clean.
I don't usually expect defendants to come up here and acknowledge that they've violated a bond condition, so I'm glad to hear that at least, but go ahead.
Thank you. So he's, so I would ask Judge that he be put on probation because the underlying drug problem wouldn't be treated.
What happened with his assault with intent to do great bodily harm, less than murder probation violation out of the Third Circuit Court? Does he still have that outstanding?
He has that, Judge, but we are handling that. I am going to take on the case of Taylor where that violation came out of. And we are going to go in front of Judge Casca, preferably this week, and turn him in on a warrant. He wanted to come and take care of this, but we're gonna take care of that warrant and tell the judge we're fighting that case, Judge.
Okay, why isn't he showing up on that? The date of that warrant was only June the 18th, but nonetheless, he received notice. Why didn't he show up?
Judge, I don't have a good explanation for that, but we can go there immediately. I'm going to circuit court right after this, Judge. If you'd like, I can take him with me and turn him in for his warrant.
Okay, go ahead.
Thank you. And that is all I'd like to say on my client's behalf at this time.
What are you doing? What are you doing? I don't know how many chances you think you're gonna be given. I get the fact this is a first drug or drunk drive. I'm not looking at things in an isolated fashion like that. You got a big problem. Well, I'd like to believe you've changed, but it's hard for me to believe you've changed when you had assault with a dangerous weapon in 22. Granted, this is a 23 case. Then you were convicted of assault with intent to do great bodily harm and felonious assault. Another count of felonious assault in the Third Circuit. Then you had an aggravated assault out of the Third Circuit. So they must have pled that down from an initial felony. Then you were arraigned on a charge. You have a case out of the 23rd District Court for malicious destruction of property. Now, that's just an arraignment. Maybe you weren't even there. Might not have been, it might have been somebody else. I don't know. Then you were arraigned on a charge of domestic violence out of the 23rd District Court on a charge of domestic violence, same date from the MDOP. Also arraigned on a charge of assault and battery out of the 23rd. Now, again, maybe you're innocent in all those. Maybe you were out of the country and somebody used your name. I have no clue. But you're not doing too good. You leave the scene of an accident here.
Understand. A lot of that stuff happened before I had a daughter. That was 2023. My daughter was born 2024.
Didn't happen before 23. The only thing that happened before
23.
this one and the felonious assault from 22 happened before you had your daughter born.
Yeah.
And it doesn't even sound like you spent a lot of time because, correct me if I'm wrong, this claims paternity to a 2-year-old daughter, but reports not paying any child support or being involved in the child's life. That's what you told probation. Is that true or is that a lie?
That's not true.
You told them you weren't involved in your child's life?
Well, at the time, I was working at Arby's and I had got a good job.
Hang on a second. Let's slow down. You just started on this case on April the 20th, right?
Yes, sir.
You reported at the time of the screening, which was on June the 17th, which was only 2 weeks ago, right?
Yes, sir.
You reported all of this to the probation department, right? And now you're saying, well, my life changed when I had my daughter, even though you had the daughter in 24 and all these other events have happened in 25 and 26. And now you're making it sound like you changed in the last 2 weeks.
Well, a lot of those things, you know, the crime was committed in them years. I wasn't convicted until
I don't want to hear anything about the charges. All I know is the probation department is recommending jail and I don't blame them. And I'm only talking to you because I'm trying to figure out how I can rationalize in my brain not sending you to jail.
Yes, sir.
Can I speak just quickly, Judge?
Sure.
As this case relates, just as this focused case is about drugs, I would argue that this case would be better treated with probation. And those other instances, Judge, you're definitely, of course, right to take note of them. But he's gonna have to answer to Judge Casca, who specifically handled that case and that violation. And deal with the judges in Taylor for the underlying facts. Judge, I would just ask for the mercy on this case to let him have probation. And if the facts of those other cases, when they're fully fleshed out, more in jail, I'm sure the circuit court will issue that.
Look at all these substances you had in your system. You had no business driving. No wonder you drove into a utility pole. It's a good thing you didn't hurt yourself or somebody else. Then you left the scene. Then you ignored the court. You didn't show up. You're lucky. You are really lucky. You know why you're lucky? I'm not going to take into account any of these new charges where there had not been convictions. That's not appropriate for a judge to do. I'm not going to do it. That's not appropriate. That's not the way our system works. Or should work anyway. But you are going to be on a short leash with me. And I am going to trust, Mr. Quartz, that you are going to take him down. You said you were taking him down today?
Yeah, well, as long as he has no objection, you can ride with me and I'll take you down there right now.
Are you going down there? Because I'm going to order you to go.
Yes, sir.
And if you don't go, you're going to serve 93 days. And you tell Judge Casca I said that.
Yes, sir.
All I know is I don't like the way your life is going so far for you, not for me. But if you end up in poverty, it's no skin off my neck. You don't have a diploma. You don't have a GED. You're making $250 per week. Maybe this job's going to pay you more. You fathered a child. You had nothing to do with the child. That's bad. I can't stand that. I think any man that impregnates a woman, if you don't take responsibility for that child emotionally, financially, well, then you got a lot of answers to give yourself when you look in the mirror the next time. But I'm not going to penalize you for being a bad father. I'm not a social worker. I'm not a priest. You are on such a short leash with me, you have no idea. On the drug driving, the operating while impaired due to the consumption of drugs. This is the sentence of the court. You cannot leave the state without the consent of the court. You cannot violate any law or ordinance. By the way, do I have proof that he attended AA? NA? Did you show it to your lawyer?
I did not, but I do have.
Show it to him. I expect to see that you've gone twice per week since June the 17th. If there aren't at least 4 on there, I hope you brought your toothbrush.
Judge, just for full disclosure to the court, so far there's only one listed, but we'll get them there, Judge.
Okay? You're not taking it seriously then. And I don't want to hear any more. She talks cheap to me. Had you gone to AANA, I was not going to send you to jail. Now you lose.
Well,
Now you lose. I don't want to hear another word. I don't want to hear another word. I'm not going to listen. Tells me you don't take courts very seriously.
appointed today to go to a meeting. I was actually.
Too late. Too late. Too late. 24 months probation, you cannot leave the state without the consent of the court. You cannot violate any law or ordinance. If you change your address, place of employment, or home telephone number, you must notify probation. You have to report as directed. No alcohol, no marijuana, no illegal drugs. You're to submit to chemical testing, PBTs, and ETG tests. That'll be weekly for 3 months. If you are clean, it will then be bi-weekly for 2. If you are clean, it will then be monthly. Kratom, poppy seeds, and CBD oils are prohibited. Consuming food or other items containing those substances will be deemed a violation. You're to obtain and maintain employment and provide proof. You're to obtain a high school diploma or a GED. You're to attend AANA twice a week until you are in an outpatient substance abuse treatment program. Once you get in outpatient substance abuse treatment, you no longer have to attend AANA. You're also to attend the Victims Impact Panel. That is one night put on by Mothers Against Drunk Drivers. Defendant to surrender to the Wayne County Circuit Court for probation violation hearing on warrant entered on June 1826 within 2 business days of his release from jail. Now expect proof of that. You are to serve 12 days jail credit 1. You're going to serve 6 now, and you're going to serve 5 more days on the court work program pursuant to the probation order. There's a $35 a day charge for that for a total of $175. You're to pay fines of $300, costs $250, $75 victims' rights fee, $50 justice assessment, that's $675, screening fee $60 for $735, probation fees are $40 for $1215, plus your court work program fees, the total's $1390. If you violate, your probation could be revoked, you could be incarcerated for 93 days, you have 21 days to appeal, 14 days to apply for a court-appointed lawyer for purposes of appeal. On the failure to report a property damage accident, I'm simply going to go 100 fines, 100 costs, 75 victims' rights, $50 justice assessment, 3 1/4, 5 days court work program days concurrent with that I imposed on 25B147048A. I will simply go out of my way and give you credit for time served on the no proof of insurance. Defendant given credit for time served on the no proof of insurance, Heather, but he still must pay the clearance fee. So you're still going to have to pay your $45 clearance fee. Now, he doesn't have any money today, does he?
I don't believe.
You don't have any money.
I have a few dollars on my channel. Like I said, I've been working endless hours.
Okay, good. Do you have enough to pay the failure to report a property damage accident? That's 3 1/4.
No.
How much do you have?
I'm pretty sure I have like $100 on my channel.
So you're sure you can pay 100 today or not? Just tell me the truth. I'm not going to penalize you anymore.
I think it's like $90 on my channel.
You pay $90 now on that. Then you're going to pay $30 per week on that case beginning on July the 31st. If you don't have the money, you call the court. We'll go on Zoom hour before the due date at 8:30, or you can come in and talk to me on it before the due date at 8:30. Then you're going to pay on the other case, the operating while impaired due to the consumption of drugs. You have a bond of $5,000, 10%. I'm pretty sure we can apply that. With the 10% because he's not been discharged from obligations with the court. So you're gonna pay $450 now on that and $30 weekly after fines costs paid on 7048B. You are in custody for the next 6 days. I'm not gonna change my mind. Maybe next time you'll understand you're gonna comply with my orders. If you don't, you're gonna end up going back. It's time for you to grow up. You're 22. Get away from this criminal activity. Start acting like an adult. Good luck. Thanks, Mr. Court.
Thank you, Judge.
Jaroslow Siamonic, 265-415-32. Good morning.
Molden.
I hope I didn't scare you after that one. Your name?
Charles Smith.
All right. Okay, you're gonna plead impeding, right?
Yes.
Responsible or not responsible?
Responsible.
Please accepted, speeds dismissed, 170 is your total. You can go down the hall and take care of that and you're all set. Good luck.
Okay.
Stephen Lee Miracle Jr., 25B148937. Morning, sir. Your name?
Stephen Lee here.
All right. You are charged with larceny. You have the right to an attorney. I'd be happy to provide you with one at public expense if you would like.
Please.
Okay, we'll give you a lawyer. You'll go out in the hallway and we will set you up with an attorney, okay?
Thank you, Your Honor.
You're welcome. Good morning.
Morning, Judge.
What are you here on?
Orator's Johnson, the sentencing, I'm ready for that.
Perfect.
This one.
Orator extension, or Oratorius Brandon Johnson, 26B150198A and B and C.
POP 8237, we have Mr. Johnson, station.
Charles Johnson.
He's another one that gets himself in a lot of trouble, huh? I mean, these are suspend, I guess, just going back to 16, but what's he doing with opiates that weren't prescribed? I mean, he pled guilty. I'm not going to take it under 7411. He's got another case where he had one. I'm prohibited from doing that. He's got another drug conviction. I don't know if we covered that, but I'm not going to take that under 7411. It's good.
Never had any.
2014. I didn't say pills. I don't know what it was.
That was marijuana.
No?
2014.
I can't do it. So if you want to go talk to the prosecutor again, you can. If you want to tell me, Judge, we'll just accept that as a plea as charged, that's fine. I will still honor the other charge, the resist and obstruct under 771.1 that he pled to. And that was back on, what day did I take that plea? What day did I take that plea? I wasn't very good with noting this, Heather. Heather, it looks like on June 17th. So I took that plea.
Yes, Judge, it was.
June 17th. And you can just tell me what he wants to do.
He wants to move forward with the sentencing.
So you acknowledge and understand that this conviction for possession of a controlled substance will go on your record, that I'm not going to take it under section 771, I'm sorry, section 7411. The conviction will immediately enter. It will be on your record and it's not going under that statute and I will sentence you on that case. Do you agree to that?
Yes.
And you acknowledge I need not take a plea again, counsel?
Yes, Judge.
All right, I'm just gonna, just give me a second to make a note. Case not taken per 7411. Please make a note of that, Heather, because defendant had prior drug charge in 2014, prior drug conviction in 2014. So I'm just gonna go ahead and sentence you anew on that. And with that, counsel, we have a plea as charged, possession of a controlled substance. We have a plea to resist, hinder, and obstruct an officer. And that's going to be taken under section 771.1. And then there was an expired plate charge that the prosecutor agreed to dismiss file C. So I'm only going to deal with files A and B. Have you had a chance to review the report with them? And are there any material additions, corrections, or deletions?
We have just, there are no additions, deletions, or correction.
Anything that you would like to say on his behalf?
Yes, Your Honor, as the report said, he is employed, he has a couple of children. I would ask when the court, if the court is gonna order any days on that court work program, if the court would take into consideration that Mr. Johnson does work full-time. He does like to spend time with his kids on the weekends, so I would just ask if the court would take that into consideration. Other than that, Your Honor, we would ask if the court would adopt probation's recommendation.
Anything that you would like to say?
I apologize for the time that I took for the work. I do have a 1-year-old and a 4-year-old that's autistic, which I take care of. The mother is not working at the time. I don't do any drugs. Everything I have done is marijuana. I have a marijuana card. The pills that I did have in the card that was in my possession, but I don't take any type of prescription pills or I don't drink alcohol or anything like that. And I do agree with what you said, the other case about violence. So I just wanted to let you know.
Well, I want to, that's nice to know, but why would you have possession of something if you don't use it? Why would you have possession of opiates that were not prescribed to you, that you reported you obtained from another individual? Why would somebody acquire something? You have to take your hat off, please, sir. Why would somebody acquire something and have it in their possession if you're not going to use it?
At the time, Your Honor, there was the person that was fixing on the car that wasn't mine. It was a new car, and when I was dropping the car off, I was taking everything out of the car, and I did put them in my pocket. The person who prescribed me had a prescription for them, and at the time, I did have an ruptured eardrum things, and they wouldn't prescribe me anything.
So you were just going to self-diagnose?
Yeah, they only gave me some antibiotic drops, so that was in about never got a chance to take. I didn't even know exactly what they were, so I didn't have any intention on like had a look or not, but I haven't took any type of other medication in years.
So you drive out to Ann Arbor every day?
Yes, Your Honor. I work for a nonprofit in Ann Arbor. Recently, I've been there about 10 to 11 years. Drive about 40 minutes from Trenton to Ann Arbor.
And are you primarily, you still reside, correct me if I'm wrong, with the mother of your children?
Yes, we've been together about 15 years.
Okay, so does she work?
She was working for,
I didn't ask you.
oh, no, not right now, she's not working. We have a 1-year-old that she's taking care of full-time, so she's not working.
You gonna straighten out your life here?
I thought I had. I haven't been in trouble in a few years, so I think
But then you tried to evade the police, right?
no, actually,
You didn't try to evade the police? You told me at the time of the, hang on. I asked you what the basis for the resist and obstruct was. You said you didn't stop when you knew they were trying to pull you over. Do you want me to go listen to the tape?
no, you're not there.
Well, is that what happened or is that not what happened? I'm not trying to trick you. I just don't want you to come up here sounding like a choir boy when you tried to evade the police. They could have charged you and should have charged you with fleeing and eluding. You got it? Can we agree to that? I don't want him just to tell me he agrees if he doesn't agree. I'm not trying to trick anybody here. That's not what my purpose is. I just want to have a discussion with you and try to figure out why I think that you're going to do better. And I can't say I see a lot of reasons on that right now. All right, counsel, what else? Anything else that you want to say? I mean, if I'm missing something, feel free to tell me, Judge. I don't think you're looking at this right.
So Your Honor, that night, it was dark outside. Mr. Johnson did see police. I don't think it was an intentional invasion at first. It was he thought they were behind somebody else, but it was dark and you got all these police lights behind you. So once he realized it, which was a mile or so later, he did pull over. But it wasn't an initial, I'm gonna run from the police.
Well, at some point he had that mindset. Is that true or false? If it's false, then I shouldn't have never have taken the plea. right?
It was a situation, again, Judge, it was dark. You got all these.
I know, but I'm just asking you, if he wants to withdraw his plea because he doesn't think he did anything wrong, I thought at the time he told me he drove when the police were following him, and I'm not trying to, listen, I'll let you withdraw your plea right now if you want. If I made a mistake by accepting a plea that I shouldn't have accepted, I'm gonna let you withdraw your plea.
Yeah.
I thought you told me at the time of the plea because I couldn't understand the basis for the resist and obstruct because you didn't provide me any in the beginning. Was that yes, you knew the police were coming after you and you continued to drive. Did you tell me that or not? I'm just asking you, did you tell me that or not? I know how I do things and I know I don't take pleas when there's not a factual basis. I know I don't do that. If I do, I've made a mistake. And if I've made a mistake, I'm going to rectify that mistake and allow you to withdraw your plea right now. And I'm serious about that. In fact, I'll let you go talk to him about that. I'll be glad to do that because I don't want to take a plea from anybody to anything that's a criminal charge of any kind if they didn't commit the act. And I thought that's what he told me. If I misunderstood, it's my fault. I'll accept responsibility. I'll let him withdraw his plea. We can go back to square one and you can go back and negotiate with the prosecutor. But I thought I heard him say that. If he didn't say that, then that's my fault.
Well, Judge, I think what he said was he knew they were behind him and he should have pulled over. I guess even just to be sure that they were behind him.
Let's speak to him.
I don't want you to say anything right now without talking to your lawyer. Would you talk to your lawyer first and make sure that we think that you're guilty of that offense? Because if I misunderstood what he said to me, I do not want to go forward with the sentencing on the RNO. And in fact, if he's not guilty of that, maybe the prosecutor can reevaluate and decide she wants to dismiss that case. I don't know. But I'm not going to take pleas and then have somebody come in at sentence and tell me something different than what I thought they said. So if he said something that I misunderstood, my fault, I take responsibility, and you guys can go back and talk to the prosecutor. But I think you should talk to your lawyer before you say another thing, okay? And again, so you got two charges, and if he doesn't feel like he's guilty of the RNO, I don't want to plea. Okay? Thanks. Raymond Lawrence, winner the second, 26B151596.
Good morning, Your Honor. Deanne Fitzgerald, 82378 on behalf of Mr. Winter.
Raymond Lawrence, one for the second.
Good morning, sir. This charge here is a malicious destruction of property, and you're requesting a bench trial, is that right?
Correct.
You have the constitutional right to a jury trial, sir. If jury trial, 6 people would be impaneled, all 6 would have to agree that you are guilty beyond a reasonable doubt in order for you to be convicted. By waiving your right to a jury trial, I will be the one who will solely decide your guilt or innocence. Do you understand?
Yes, sir.
You wish to waive your right to a jury trial?
Yes.
Anybody in the world force you to do that?
No.
I'll accept the waiver. We'll set it for bench. What do you have for me, Heather?
Judge, do you want to do this bench trial on one of our Wednesdays or one of our Thursday Brownstown days? Or do we
Probably
need to do it when Miss Patillo's here?
Ms. Patil's here on Thursdays?
I don't know if she has any Thursdays with us.
No, I don't. I have some Wednesdays, no Thursdays, and 33rd.
Can I get you to come in on a Thursday, or do you not have?
It depends on the date.
How do I look on the 16th, Heather?
Let me, we,
Or is that,
I'm on another quarter.
how about on the 30th?
we don't have Brownstown on the 30th.
I don't have Brownstown on the 30th?
No, we have them on the 16th.
I thought I had them every 2
Or
weeks.
I don't have them on our docket for the 30th.
And the one Thursday a month, you have Brown.
I see. How about, what do I have on the first Thursday in August? Can I do it then or not?
We actually don't have them until August 20th.
I'm sorry, Heather, I didn't hear you.
We don't have them till August 20th in August.
I can do August 20th. Are you available?
Yeah, actually, I am on council.
I'm here that day, right?
Yes, you are, Judge.
I'll do August the 20th. August the 20th at what time, Heather?
Since it's a bench, do you want to do it at 11?
Sure. 11 a.m. on August the 20th, okay? So, sir, you'll go down the hall, we'll give your notice and see you on August the 20th. Any questions? Anything else on that, Ms. Patillo?
No,
Do you want these files back on the other one, or you want to just go talk to them? Thank you. Okay, Lillian J. Star Trotter, 26B15073 A and B. Good morning, counsel. How are you?
I'm doing well, Judge. Kenneth Camilleri on behalf of Lillian Trotter, Your Honor, who's sitting to my right.
Okay, I'm getting a little, can you get that device a little closer to you? Ma'am, tell me your name, please.
Lillian Trotter.
All right, just keep your voices up nice and loud if you would. I don't know, it's not coming through as strong as it usually does. So I have a plea agreement here that says that the defendant is going to plead guilty to the added count, lesser included offense, I should say, of operating while visibly impaired. The super drunk or high BAC charge would be dismissed. Also, that the defendant is going to plead responsible on count 2 to an amended charge of distracted driving. And the prosecutor then is going to move to dismiss the open intox. Is that right?
That is a correct statement, Your Honor.
Ma'am, is that what you would like to do?
Yes, Judge.
If you plead guilty to operating while impaired, here are the possible penalties. Up to $300 fines, 93 days jail, 360 hours community service, court costs, or all those, 4 points, license suspension or revocation in accordance with your record. Your vehicle could be or might have to be immobilized depending upon your record. If you plead to distracted driving, that's a 0-point civil infraction. You understand that? It won't get reported. Do you understand that?
Yes, Judge.
And then I'm going to dismiss the open intox and the super drunk. You understand that?
Yes, Judge.
I want you to understand that you are presumed innocent. They have to prove you guilty beyond a reasonable doubt. You have the right to remain silent. You have the right to a trial. At a trial, you have the constitutional right to a trial by jury. You could subpoena your own witnesses. You could testify or remain silent. If you remain silent, the fact finder would be instructed that they could not hold that silence against you. If you plead guilty, you're giving up all those rights. You're giving up the presumption of innocence. You're waiving the requirement that the people prove you guilty beyond a reasonable doubt. Do you understand all of that?
Yes, Judge.
You fully understand everything.
Yes, Judge.
To the charge operating while visibly impaired, ma'am, how do you plead?
Guilty.
Were you operating a motor vehicle on West Jefferson near Campo in Brownstown, May 2nd of 26 at 2:30 in the morning?
Yes, Judge.
Prior to that, did you drink alcohol? And if so, what did you drink and how much? Nice and loud for me.
Yes, Judge. I had about 8 bush lights.
And was your ability to operate that motor vehicle impaired due to the consumption of the alcohol?
Yes, Judge.
In what way? Why were you pulled over by the police?
I hit a curb and wrecked my truck.
I'm sorry,
She stated she hit a curb, Your Honor.
you hit a curb when you were driving?
Correct, Judge.
Is that right, ma'am?
Yes, Judge.
Was there an accident then?
There was a 1-car accident, her car, Judge.
What did you drive into then, ma'am?
The median. In
A what?
The median in the road, Judge. There's a new median on West Jefferson.
All right, so you drove into the median and then the police came to the scene?
Yes.
And were you administered a breathalyzer test at the police station or was this a blood draw?
Blood draw, Judge.
Blood?
Yes, Judge.
And do you stipulate that the reading of 0.205 was an accurate reading for purposes of the plea?
The defense would stipulate, Judge.
I'm sorry, I don't know why I'm having a hard time.
Yes, Judge.
Are you on probation or parole right now, Ms. Trotter?
No.
Anybody force you to plead guilty?
No.
Into the charge of distracted driving, you plead responsible or not responsible?
Responsible.
Plea is accepted to distracted. Plea is accepted. I find it to be an accurate plea, operating while impaired. I'm going to go ahead and dismiss the super drunk charge on motion of the prosecutor, as well as the open intoxicants on motion of the prosecutor. I'm going to refer you for a screening and assessment. They're only requesting 168. I give 2 1/4 on the blood draw, but if that's the extent of their bill, that's what they're going to get. We're going to have a screening and assessment. You're going to have to come up here, fill out a questionnaire, and be interviewed. Has she been going to AA, and did she show you proof of that?
I have seen the sheets, Judge. Yes, she's attending as required under her bond conditions.
All right. I didn't realize the breathalyzer, I don't think, was this high. It's pretty high. I'll still keep it at once a week, but I need full compliance. Do you understand that?
Yes, Judge.
All right, so let's get a sentencing date for you, Mr. Camilleri. What do you have for me, Heather?
July 15th at 8:30.
Is that good with you?
Yes. Yes, Judge.
All right, we'll do July 15th at 8:30. I'm deferring the sentencing on the distracted. I'll sentence you at that time, but I do need you to come up to the court and meet with probation and fill out your questionnaire and be interviewed. Okay, ma'am?
Yes, sir.
All right. You seem very respectful. This is a lot of alcohol. We're going to make sure you don't have a drinking problem, okay? And take care of that, all right?
Yes, sir.
Good luck to you. Thanks, Mr. Camilleri. Have a good day.
Have a good weekend, Judge.
You too. Thank you. Angela Ardith, Rice Day, 26B 838-848, and B and C. Where I got this one. Your name? Ma'am, you're charged with Animal Vicious Act, and you also have 2 civil infractions, dog at large and no license on the dog. You have the right to an attorney. If you want one, I will give you one. Would you like an attorney? All right, I'm going to provide you with an attorney, and you can go out in the hall, and we'll set you up, and we'll go from there. Okay, thank you. Do I have Scott, Terrell Dwight Scott, 26W842-496, 26W842-665.
Good morning, Your Honor. Crawford representing Mr. Scott. Mr. Scott, please state your name for the record.
Terrell Dwight Scott.
This is, okay, so what are we doing here? This says he's going to plead guilty to stalking on file 2496. That's offense date June 25th. They're going to dismiss, if he pleads to that, the trespassing charge on file 26W842-665. That's a different offense date. That was April 26th. But it also says here, defendant has 2 new trespassing cases scheduled for July 13. Somebody wrote down, let us know if you want us to pull them. Who, is that your handwriting, Heather?
Oh, it was mine, and it was directed to Mr. Crawford or the attorney.
Oh, I see. So I'm just gonna go ahead with these 2 now, and then we'll go from there. If you plead guilty to stalking, they've only charged you under local ordinance. It is punishable by up to 500 fines, 90 days jail, costs, or all those. Do you understand that, sir?
Yes, sir.
If you plead guilty to that, the prosecutor is going to ask me to dismiss, and I will dismiss 26W842-665, that trespassing charge. I will also tell you that the possible penalties on this are up to $500 fines, 90 days jail, court costs, or all of those. Do you understand that, sir?
Yes, sir.
Now, you are presumed innocent. They have to prove you guilty beyond a reasonable doubt. You have the right to a trial. At a trial, you have the right to remain silent. You have the right to question their witnesses. You have the right to bring in your own witnesses. You have the right to use the subpoena powers of the court to bring in your own witnesses. If you choose not to testify, that silence would not be held against you at a trial. If you plead guilty, you're waiving your right to a trial of any kind. You're also waiving the presumption of innocence and the requirement that they prove you guilty beyond a reasonable doubt. Do you understand all of that?
Yes, sir.
All right. Do you have any questions before I ask how you plead?
No, sir.
On June 25 or 20, first of all, to the charge of stalking, how do you plead?
Guilty.
Hang on a second. You act like you're bored.
No, sir.
You're bored. Is this what you want to do?
Yes, I'll take it. Yes, sir.
Don't act like you're doing anybody any favors. This is important. If you don't
Yes,
want to
sir.
plead guilty, just tell me. We'll stop the process now. If you do, tell me that. Do you want to plead guilty or not?
I plead.
To the charge of stalking, how do you plead?
Guilty.
Were you at or near 25338 Oxford Street in Woodhaven, June 25 of 26 at 3:22 in the morning?
Yes.
And were you at the property of an individual by the name of Christine Weisend?
Yes.
Okay. What did you do that makes you guilty of the offense of stalking?
Knocked on the door.
Crawford, did he do anything else besides knock on the door at 3 o'clock in the morning? He had to, or they shouldn't have charged stalking.
Your Honor, my client showed up at the residence in question after being warned and trespassed several times in the past, and he defiantly showed up at his home and knocked on the doors throughout the night with the knowledge that he was not welcome there by the alleged victim.
And the alleged victim was not alleged victim or victim Christine Weisend, right?
That is true.
Yes. Okay. Had Christine Weisend advised you on multiple occasions not to go back to her residence?
I believe you have, yes. I believe so, yes, sir.
Your Honor, to assist my client, I might remind him that the police also told him that he could not return to this property several times in the past. Isn't that true,
Scott,
sir?
if you don't want to plead guilty, we'll set it for trial. I'm not gonna ask you a bunch of questions here. You're gonna tell me yes or no. Did she tell you or did she not tell you on multiple occasions not to go back to her residence?
Yes.
On how many occasions did she tell you not to go back to her residence?
I'm not sure. A few times.
What's a few mean? 10?
About 3.
And did the police also tell you not to go back to her residence?
Yes.
Had you previously dated her? What was the relationship here?
Yes.
So she broke off the relationship. Is that fair?
Can you repeat that? I can't hear you.
Did she break off the relationship?
I think the evictions broke off the relationship, not so much as she or I did.
She tell you that she did not want you to go back to the residence?
Not due to the relationship issues. It was more to the fact more of, I guess, me being evicted from her property or something like that.
Your Honor, if I could assist the court, the alleged victim filed for eviction against my client.
Is that true?
Yes, sir.
So she filed, you guys lived together for a while, right?
Yes.
The property was in her name, correct?
As far as what I seen on the paper, I guess so.
And then she filed a notice to evict you, a 30-day notice to evict you from the property. Is that true?
Yes, sir.
Were you evicted from the property by a judge of this court?
Yes, sir.
Is that in front of me or Judge Hessen?
You, I believe.
Okay. And after that occurred, did you continue to go back in a contact her or appear at her residence?
Yes.
Did she tell you not to come back on several occasions?
Yes.
Did the police tell you not to come back on several occasions?
Yes.
And did you then knock at her door at 3 o'clock in the morning after you'd been warned by her repeatedly not to go back, and after the police had told you on June 25th, specifically at 3:22 in the morning?
Yes.
Probation or parole?
No, sir.
Anybody force you to plead guilty?
No, sir.
Is it fair to say that she told you she didn't want you to go back because she wanted to and evict you because she wanted to not have a relationship with you anymore?
Those wasn't the exact words, but I guess it's not fair that I still went.
What's the exact words?
I can't hear you, sir.
What were the exact words? I'm feeling like a dentist again, Mr. Crawford.
know.
What were the exact words? Why did she tell you she wanted to evict you?
I never really got, well, as far as what the paper says, it said that I was a nuisance to her pregnancy. A nuisance to her pregnancy. I was, I guess you want to say sexually harassing her verbally.
Okay. Why'd you make me sit here and ask you questions for 7 minutes? Please, are you on probation or parole right now?
No, sir.
Anybody force you to plead guilty?
No, sir.
Something troubled me here, Mr. Crawford. I see the bond I set. I don't usually do that. But I'm going to order a pre-sentence report. I'm accepting that plea. I'm dismissing the trespass. I'm going to order, again, you're not to be released until fitted with a GPS tether. You're not to be within 2 miles of her residence or place of employment. You have to be on that tether. You're not to possess firearms or weapons. You're not to enter or go anywhere near 25338 Oxford and Woodhaven. No contact with prosecution witnesses. No contact with the victim. If I find out you're having any contact with her of any kind, whether from there or otherwise, either by text, voicemail, email, letter, contacting her through people, or showing up at or near her residence or place of employment, I'm going to give you a maximum here, sir. Do we understand one another?
Yes, sir.
All right, trespass is dismissed, bonds continued. We're going to give you an early sentencing date, and I'll look into this. When can I sentence him, Heather?
We could do July 13th at 1:00.
Good enough. Is that good with you, Mr. Crawford?
Oh,
It
you
is,
know
right?
what? Yeah, I would say we have to. Is Mr. Crawford here that day, or could he zoom in for the sentencing?
At 1:00, I could zoom in. I'm not here otherwise. I am here on 14th.
Heather, cancel any bond conditions that are not common. Well, I guess they all are, but we're going to take them out on the trespass. We're keeping them on the stalking charge. The trespass is now dismissed. That's what we'll do. July 13th at 1. I wish you well. Good luck. We'll see you then, sir. Stay away from that lady. And if there are more trespass charges, I certainly hope that they are not coming in front of me if they involve this victim especially after an order that I gave. That's all I'll say about it. Are they, Heather? Do you know?
Sorry, Judge, my one earbud went out. What was that?
I just want to know if you know whether or not the new trespassing cases involve him contacting her.
I do not know on that, Judge. I can pull them and look real quick if you'd like me to.
They are your cases and they are scheduled for the 13th. That's today's coming back in class.
Why don't you stay right there, Mr. Crawford? You stay right there. Bring those files down here, please.
Okay, you want them down? Okay, I'll pull them right now.
I'll go on to another case in the interim. Salvatore Gabriel D'Amato, 26B83910A, B, and C.
Good morning, Judge and staff. John Bronstein, attorney on behalf of Salvatore D'Amato. Please step to the podium, sir. My left, please identify yourself, sir. Salvatore Gabriel D'Amato.
All right, good morning. Counsel, I need to know, does he stand mute and wave formal?
Yes, he does.
What kind of a dog is this allegedly?
It's a female German Shepherd that weighs, I believe, approximately 72 pounds.
Does Mr. D'Amato have a fenced-in yard?
He does, sir, and everything has been taken care of. This is an unfortunate incident that, in my opinion, has been blown up in proportion. There's, any touching that was done, do nudge, but nonetheless, he's willing to take care of any vet bills, but nonetheless, we, waive a formal rating and stand mute.
Not guilty plea is entered?
We determine where you judge.
Yeah, I'm gonna give him a personal bond of $500. It says dog on dog attack. You cannot leave the state without the consent of the court. You cannot violate any law or ordinance. Defendant's dog. Do you have more than one, sir?
No, sir.
It must be in your house. It must be in your house, in a fenced-in area, or on a leash, accompanied by defendant, and equipped with a muzzle. Do you understand that, sir?
Yes, sir.
So otherwise, you're not taking the dog out of your house or the backyard. You understand that?
Yes, sir.
All right, we're gonna give you those.
My eyeglasses are messing with my hearing aids.
No problem. Do you understand everything I said?
The last part kind of cut out on me. I'm
Your
sorry.
dog must be in your house, in a fenced-in yard,
Yes.
or on a leash, accompanied by you and equipped with a muzzle. Do you understand that?
I do, sir.
Okay. And you're not to have any contact with prosecution witnesses. I'll give you a new pretrial date, Mr. Graziani. What do you have for me, Heather?
July 15th at 10 o'clock.
July 15th at 10 a.m. in the morning will be the court date. July 15th at 10 a.m. and you can go down the hall and get your paper notice. And I'm entering pleas of denial on the civil infraction charge.
Okay, thank you so much, Judge.
Thank you.
Thank you, Your Honor.
All right. Peebler, Kyle Stephen Peebler, 26B838059A, B and C. Did you have a lawyer, sir?
Yeah. Okay.
Okay, your name?
Kyle Stephen Mueller, Your Honor.
So this says on the bottom, prosecutor moves to dismiss vicious act as defendant voluntarily euthanized the dog. Prosecutor spoke to victim and was advised that defendant paid all related expenses and she does not wish to make a statement. So they're going to go ahead and dismiss. I'm sorry about your dog. I really am. And I'm going to go ahead and dismiss that vicious act. And then, as I understand it, you are going to plead responsible to one count of dog at large with the understanding that the no license and the vicious act dog charge will be dismissed. Is that right? Can you pull that out and tell me what our fines, the dog at large things are, please? All right, to the charge, dog at large, responsible or not responsible?
Responsible. Yeah.
Judge, it's 135.
I thought so. I'll accept the plea. Fines cost of 135. I'm dismissing pursuant to stipulation on motion of the prosecutor, both the no license charge as well as the vicious act charge. Okay?
That's right.
So you can go down the hall, take care of the fines, 135, and you're all set. Best of luck to you, sir. Thank you.
There's a fines on Scott.
All right. Mr. Crawford, can you hear me?
Yes, Your Honor.
I can bring him to you, these to you. These happened after? You better look at these.
I'll come grab the file, Your Honor.
Giles, Daniel Curtis Giles.
Yep.
25T64605-3A. Your name, sir?
Daniel Giles.
All right. You have to pay 200 monthly starting July 1. You're here for time to pay. When can you start paying?
If I could get just a few more months.
Well, I got to get going on.
Imagine being warned again and again to stay away from someone, only to ignore every warning until you find yourself standing in front of a judge. That's exactly what happened in this real courtroom case. At first, it seemed like a straightforward guilty plea, but the more the judge questioned the defendant, the more serious the situation became. The judge learned that the defendant had previously been in a relationship with the alleged victim and had lived with her. After the relationship ended, she legally evicted him from her home. It wasn't just a breakup, it became a legal matter. The judge carefully asked whether the victim had told him not to return to her home, and the defendant admitted that she had. The judge then asked whether police officers had also warned him to stay away. Once again, the answer was yes. But despite those repeated warnings, the defendant admitted that he went back anyway. Even more concerning, he confessed to knocking on her door at around 3 a.m. after both the victim and the police had clearly instructed him not to return. That admission immediately changed the atmosphere inside the courtroom. As the hearing continued, the judge wanted to understand why the defendant ignored every warning. The defendant explained that he believed the problem started because of the eviction, but his answers became increasingly uncomfortable. Eventually, he admitted that the eviction paperwork accused him of being a nuisance and even verbally sexually harassed